Let's get to the celebration. Let's get to the 9-0 decision from the court. What happened?
Absolutely. So there you had, and this has implications for President Trump and for all conservatives, for all Republicans. You had, in the beginning, in the earlier stages of weaponization of the government, former New York Governor Andrew Cuomo had said, we're going to go after the NRA. And, Letitia James, the Attorney General, ran for office promising to target the prosecution resources of New York State against two targets, President Trump and the NRA, the National Rifle Association. And she has certainly done so on both, frankly. But on this aspect with the NRA had filed suit. Well, because Cuomo's people came out, Cuomo's administration jumped into action. And in this case, you had where he said, my government's going to go after the NRA. And Maria Vullo, who is the director of the Department of Financial Services, DFS, for New York state government under Cuomo, had said, sure, yeah, we can do that. And so she was going to all the financial and insurance houses in New York saying, hey, we're your regulators. We are your regulators. And we regard NRA as a high-risk organization. For that matter, I mean, there are New York politicians who have literally called it a terrorist organization. The NRA called it a terrorist organization. And so she went and she said, you're doing business with some very, very shady and dangerous people here. That's what the NRA is. And she says, the terms of how we regulate you is determined in part on our risk profile of your company. And if you're doing business with an organization like that, an extremist organization, we're going to have to upgrade your risk. And that's going to have some serious regulatory problems for you. So, so you're going to have to make a decision about whether you think it's a good idea for you to continue doing business with these radical, dangerous extremists. And so they all got the message. And so it was like Lloyd's, which is an insurance company, because understand, I mean, the NRA, they've got like a big 6-story building in Fairfax, Virginia. You have to have insurance for that building. And they need companies that process, they have hundreds of millions of dollars of revenue each year. You need financial institutions that process the credit card payments for membership dues and stuff like that. Yes. And so you could kill an organization by cutting it off from money and making it unable to have insurance, including insurance even for its facilities, which it's required by state law to actually maintain. And so the NRA had filed saying, hey, this violates our First Amendment rights. Ironically, First, not Second Amendment. They say because we have a First Amendment right to be advocates for what we believe, in our case, advocating for support of the Second Amendment. So for you to use the levers of government to come after us, for you to weaponize government because of our political beliefs, is a violation of the First Amendment. And as that case went up on appeal, the U.S. Court of Appeals for the Second Circuit, ironically the same one we were just talking about, they went the wrong way on that issue. They said, no, we don't see anything wrong. There's no constitutional violation being claimed here, and had allowed a dismissal of the case where you don't even get into anything. It's saying the way a motion to dismiss works is when you file a lawsuit, that's a complaint. A motion to dismiss, there are several forms. The kind here says, hang on, Judge, even if you consider as true all of the facts alleged in this complaint, all of the accusations in this complaint, even all those facts, if they were true, still would not violate the law, and so you should just dismiss it. It's called a 12b6 MTD. And that's where the Second Circuit said, yep, this should just be dismissed. That's what went up on appeal here, and the court emphasized that to say, we're not even saying whether or not the facts are true, whether the accusations by the NRA are true. We're just saying that at that first stage of litigation, it's well settled that a court has to assume those facts are true at the dismissal stage. And they're like, you're kidding. Under our under our settled precedent, most specifically a prior case called Bantam Books, if these allegations are true, this is an egregious violation of the First Amendment. And so you had a 9-0 decision from the U.S. Supreme Court saying that, written by none other than Justice Sonia Sotomayor from New York, who is as ardently, not a fan of the court's Second Amendment decisions as anyone on the Supreme Court. You would not find someone on the court who was less predisposed to rule in the NRA's favor, and yet it was a unanimous decision that she wrote. And I give kudos to Chief Justice John Roberts for saying, okay, Justice Sotomayor, how about you write this one? Because this is the last one, because it's the authority, the senior most justice in the majority gets to assign it, and so it would have been Roberts who assigned it. And by giving it to Sotomayor, I mean, it's like that's the last person in the world where it leaves it on the table for the left to say with any credibility, well, this is a right-wing activist court. Yeah, it's Sonia Sotomayor. So if you're to the left of her, you're just an authoritarian.
Wow, this is amazing. Okay, so just to go back, because I was wondering as you're talking, like, who did they go after? Like, what they went after all these choke points for the NRA to try to suffocate them. Yeah, so it's like I wonder how far they went. I'd love to see a list of it. Like, did they go all the way down to like the janitorial company?
Well, you know what?
Make it illegal
now
for
that the motion to dismiss has been denied, that means the lawsuit goes forward. That means we now get into discovery. And so now the NRA's lawyers are going to be able to get their hands on every email, every text message, every internal memorandum, every scrap of paper in the entire New York Department of Financial Services, also between the department and the governor's office, between the department and Letitia James, Attorney General's office. All of that will now be anything that's not covered by attorney-client privilege is now going to become discoverable. And it's now, of course, it is a felony to be shredding documents to make them unavailable. And so we can assume there's going to be an awful lot of documents now that they'll get a hold of, and maybe even some documents. It's quite possible in things of this nature. It's quite possible that documents have already been scooped up, that they're just like sequestered off where the NRA's people couldn't see them at this stage. But I think there could be a mountain of documents now that could include more than one smoking gun as to just absolute determination to weaponize the government against Americans and this organization for exercising their civil rights.
And listen, I don't want to put this on you, Ken Klukowski, but there's some talk out there that maybe some Republicans who are in charge now should start charging some other people with felonies.
Well, I'll tell you, there comes the question, all right, during the 1980s, the Democrats loved to use independent counsels against Republicans. And it went to the U.S. Supreme Court in 1988. In the case Morrison v. Olson, the court 8-1 said, yes, independent counsels are constitutional, that they're not Senate confirmed, but they're what the Constitution calls inferior officers, and you do have this law on the books that expressly creates them. That was an 8-1 decision. The dissenter there was a recent addition to the court, a young Justice Antonin Scalia, who had this epic takedown as to why independent counsels were just entirely unconstitutional. Everyone in the years since, the consensus view in the law now was that Scalia was right, everyone else was wrong. Justice Elena Kagan, a liberal, had said, during a congressional hearing many years ago, in fact, during her confirmation hearing, had said, Scalia's dissent from Morrison v. Olson sounds better every time you read it. During one of the Trump cases argued at the Supreme Court this year, Justice Brett Kavanaugh said during oral argument, this court really needs to overrule Morrison v. Olson, meaning taking up Scalia's dissent. So you had all of this stuff, and Democrats are like, no, we love independent counsels. Then you get from the 1980s to the 1990s. Then you have Ken Starr, All of a sudden, Democrats found out what independent counsels were like, and they're like, wow, this law sucks. We don't like independent counsels. And all of a sudden, in 1999, both sides agree not to reauthorize the Independent Counsel Act, and it expired. Okay? So sometimes there are Republican strategists saying this, that in fact John Yoo, who is a top constitutional scholar on the Republican side, he had been in the elite Office of Legal Counsel during the Bush 43 years. Professor Yoo had just recently wrote in National Review where he said the only way to right the ship now that the Democrats have written a playbook for weaponizing the government through prosecutions, the only way to make this go away is for Republicans to do the same, so that both sides agree that it's mutual assured destruction to weaponize criminal prosecution. So there's a lot of conversations going on about that right now, and there are certainly laws on the books like 18 U.S.C. Section 241, which makes it a federal crime to conspire to violate people's civil rights. So it is now whether or not there'd be convictions. There's certainly material there for indictments and for people to go through the criminal justice system, during which, again, all of these documents would be captured and come to light as to exactly who planned to do what. And it's so the Democrat Party through Alvin Bragg here has pushed us, has blown through what has for 200 years been a guardrail in our constitutional form of government. And now we are in dangerous and uncharted waters, and it's leaving people wondering what must be done to try and restore those safeguards.